It started at 6:35. Thank you once again for coming to our Development Code Update Project public forum. Our guest tonight is Don Elliott from Clarion Associates. Clarion is working for the city and preparing this code, which will ultimately go to our Planning and Zoning Commission and then to the City Council for adoption. And as has been our custom, we do the code in sections called modules, and this is the third and final module tonight, which is an administration and enforcement piece. And so we do have available online now for the first time a complete new code, but Mr. Elliott's going to talk primarily about Module 3 tonight, and then he'll make some time to answer your questions. And he'll also explain the steps still to come. There's no doubt going to be a number of revisions, and we'll have an integrated revised draft later this year. The effort began last January, so we've been at it for 15 months already, and we're expecting it to wrap up at the end of this calendar year. And I'm Tim Teddy. I'm the Community Development Director. I want to say thank you to all of you, the staff that are here, members of the Planning and Zoning Commission, members of the business community, our press, and we also have some special guests from Korea via the Asian Affairs Center at the University of Missouri. So welcome all, and Mr. Elliott, want to get started?
Thank you. For those of you who have been at the prior sessions, this is a lot shorter presentation. It is about the processes that the city uses to review development proposals and the criteria and how decisions are made and how that should be changed or streamlined in the new code. So it's a third of them. There are only about, I think, 18 slides here. Not that many and not nearly as many as we've had before. I want to cover a little bit of where we are in the process, then the substance, the changes, the significant things about this third module, then where we're going, as Tim Teddy suggested. So here we are. Our main goal is to revise and integrate two important chapters of the current city code. One is chapter 25, which is subdivision. How do you divide land into new parcels for development, often for homes, but sometimes for commercial development. And 29, which is zoning. What can I build? What types of buildings and what uses can I put in those buildings? So basically the whole process was aimed at implementing the city's new comprehensive plan, Columbia Imagined, to get public involvement not only in here, but to talk about how you get public involvement in approvals, to streamline administration, to make the code more visual and user-friendly, and then for the downtown area to incorporate form-based zoning standards. Now, the last time we met, we went over that, and our subcontractor, Farrell Madden, was here. We spent quite a long time showing pictures of what form-based zoning is in a nutshell. It is land use controls that focus more on how you get the buildings to fit in with their surroundings and focus less on the uses. So you allow a wider variety of uses, but in return, you get a higher degree of control. The city's decision so far, and nothing's been approved, is that they want that for downtown Columbia. That draft was put out. I have gotten a lot of comments on it. We have not revised it yet. That doesn't mean I didn't hear the comments. It means that we're not at that point in the process. So if you have questions tonight, I can answer it, but this is not about the downtown zoning, and I have not revised the draft to make those changes yet, and that is the next step in the process. So that is an important part that many people want to talk about. Our process was kind of divided into these steps. First, we did a lot of interviews and scoping. Then we did an outline of how to organize this new integrated development code. Then we divided it, as Tim said, into 3 modules, and we put out a staff draft, we corrected for mistakes, and then we put out a public draft. And as Tim said, there are 3 modules. They are all there. So if you get on the city's website and you download this document, it's not final, it's not perfect. I've already mentioned that I have not made the changes you've asked me to make in the earlier draft, but I've collected them all. It's a big file on my computer called Comments on the Columbia Draft Code, and that's my next step. But that's where we are. All 3 are there. You got to get to this point because the different parts of the code relate to one another, and until you get all the parts together, you can't even kind of read it as a whole. Now you could read it as a whole. It's all there. Then we have a process of choosing about 6 sites around the city and testing. how would this change what could be built or how it would turn out, and are we happy with that? Or do we find unintended consequences? We didn't mean to do that. Wow, I didn't know it would prohibit that. Wow, I didn't know it would allow that. So that we try to find those unintended consequences before it goes forward, and then we make those changes and take it through the public process. We divided the drafting kind of not linearly, but the blue districts, what are the new zone districts and what can you do in them? That was what we put out first. The green was, how good does it have to be? The form controls, the dimensions, the heights, the setbacks, the parking, the lighting, the landscaping. Not what can I do with my property, but how do I need to lay it out to get an approval in Columbia in a way that hopefully implements Columbia Imagine. That was green, that was module 2. We're here tonight to talk about the purple, and that is the last chapter in the first. Most of what we're going to talk about is 29.5 procedures and enforcement. We know the draft tells you what you can do with your property, what you can build on your property, how you lay that out on your property, and this part says, whose approval do I need? Do I need to go to City Council? Do I need to go to the Planning and Zoning Commission? Who do I need, or is it just staff? Do I just file an application and they say, yeah, looks good, go? And the first chapter is simply some legal background to the whole code. So that's where we are. I'm going to skip that one. So we also are, throughout the code, trying to integrate more tables, more graphs. One of the things that's in this module now is a table that outlines all the different kinds of applications you might file, who reviews it, who makes the decisions, and who hears the appeal. So there's a table that outlines that, and footnotes where we're changing things, where we recommend changes. Because nothing's been done so far. What you have is a document that integrates, that puts out our recommendations for how we do it. I'm going to skip this because I've already talked about it. So this is what we are. I want to talk first about what I call the little chapter, basically chapter 1. Chapter 1 is where you lay out in every code, here are the things. What do we call this law? What is its purpose? Who has to comply? Where do we get the authority to do it, basically? Where is the zoning map? The fact that you must comply with this code. This is not an advisory document. Development above a certain size needs to comply with this code. I want to point out that there are some new things in here, and then who interprets the code? When does it become effective? Just a reminder that even though this is zoning, for centuries, cities have had nuisance law. If you burn garbage in the street, you are violating a nuisance law, whether zoning says you can't burn garbage in the street or not. There are certain things that happen under common law where your behavior violates the rights of your neighbors, even though it's not said in the zoning ordinance. And so there's a section that says, don't forget, every city, there are nuisances out there you can do that, I just use an extreme example, but you still have to not commit nuisances in the city. How do we transition to this new code? In a nutshell, it says, if you have a complete application filed before the day council approves this new code, you're under the old rules, unless you ask to be under the new rules. So as we get towards the end, people will say, well, should I try to file my application under the old one or the new one? If we've done our job, I think a number of people will say, I think I'd rather do it under the new one. It looks more advantageous to me than the old one. Rather than rushing, I'm going to wait. But it's important for the credibility of this process that we not rush it. People need to know this is a deliberative process. We're going to take it through planning and zoning. We're going to take it to council. We're going to make the changes that are needed. And if you happen to file before that happens, you are covered by the old code. They're not going to whipsaw you and try to stop that. So basically, that's how that's laid out. And then there are definitions, lots of definitions about terms. It's expanded significantly in this code. Now, I've highlighted the blue one just because there are some new sections in here that we just need to explain. Cities sometimes get into a situation where citizens have bought a home in a covenant-controlled community or bought a commercial property that has restrictive covenants on it, and their neighbor is doing something that violates the restrictive covenants. This section just says, that's private law. That is a condition of you brought your property with those conditions on it. The city does not enforce those. If you come in and you're allowed to do it by zoning, but you're not allowed to do it by your covenants, you take up with your homeowners association. You take it up with somebody else because the city is not enforcing your covenants, nor does zoning have to match your covenants. Now this is just, we put it in writing because people are confused about this. This is not different than the law today. I haven't changed it. We're trying to be clear. Don't call the city when your neighbor is violating their covenants. The city didn't adopt them. The city's not going to enforce them. Don't tell the city to turn down your neighbor's permit because the covenants won't allow it. That's between you and your neighbors. The city has a zoning law, and the city will issue permits based on the zoning law. So that's just clarifying the situation. I'm going to go on. Okay, that was the boilerplate at the front. Let's move into the meat of procedures and enforcement. It's divided into these 6 sections. Who are the reviewers and the decision-making bodies? Most older codes don't do this. They have kind of very old sections about the Board of Adjustment. But they don't say, who is the Board of Adjustment? Who is the Historic Preservation Commission? Who is the Planning and Zoning Commission? Who is City Council? What is staff? And basically, what authorities do they have? Almost all codes like this just because for citizens that are not zoning geeks, it helps explain, okay, they tell me I need to go in front of the Planning Commission. Who are these guys? And what are their authorities? And so that just explains that up front. Then there's a table that I described earlier, and I'll show it to you in a minute. There are standard regulatory procedures, meaning things that happen all the time that we don't want to repeat over and over again. If I have to give public notice, what is it? Newspaper? Is it mailed? Is it a sign on my property? Is it a web notice? You don't want to repeat that over and over for every application, so you state it once. How do we conduct public hearings? Many older codes have throughout the whole code. We got to pay $200 for this fee. You got to pay $700 for this fee. You got to pay $100 for this fee. And this says, no, there's one section called everybody pays the fees for their application that council has adopted. We're not going to repeat that every time. So there's a schedule. You got to pay your fees. You got to file a complete application. So that is standard regulatory procedures, things that will apply to many types of approvals, but you don't want to repeat it every time. Then there are specific ones. That's section 4, and that is where we say, you need to do a rezoning, here's how it works. You need to get a variance, here's how it works. You need to get a conditional use permit, here's how it works. You file here, you go in front of this body, here are the criteria they will use to make your decision, and if you're unhappy, here's what you do to appeal it. So those are, section 4 says, this is stuff that is different for every type of application that you file with the city, and we're just going to walk through it and put a little flow chart in there showing you who's going to make the decision. Nonconformities is about what if you were legal when you built your property or operated your business, and now the city has changed the laws. Not just what Clarion is drafting today, but say you adopted a law, you formed your business in 1990, and in the year 2000, the city changed its laws, and now you couldn't build that business, or that building today. You couldn't start that business because they changed the law. Not your fault. They changed the law. What do I do? How am I treated? And the answer always is you are allowed to continue that use. You're allowed to sell it. You're allowed to buy it. You're allowed to rent it. You're allowed to do various things to continue that use until the day you decide you're not going to do it anymore. And then when you redevelop the property, or you stop that use, then you're not going to be able to start it over again. If your property burns down completely, you'll have to build under the new code. If there's just minor damage, we're going to let you rebuild the building the way it was before. But that section 5 says, I seem to be out of step with the code and I didn't create this problem. And it lays out much clearer than the current code, okay, how will you be treated? And the general rule is, allow these people to continue to use their properties because they were legal when they created them and it's not their fault that this happened to them. 29.6 is the violation enforcement and penalties. What is a violation of the code? How do we enforce it? Who are the people with the tools? What tools do we include to enforce it? And what kind of penalties are going to be imposed if you don't bring your property into compliance? When will the penalties start to accrue? How big are the penalties going to be? So that's the end of all of these things. I mentioned earlier, and just to repeat, Don, you talked about standard procedures. What are they? Well, here they are. Everybody's got to file a complete application. Here's how we do notices. Here's how decisions are made. There's a provision in here that says, as I talked to some of the stakeholders earlier this morning, there is a provision that says, when the Planning and Zoning Commission or the Board of Adjustment you're in front of them and you're saying, look, I ought to be allowed to do this. And they say, well, we agree that you're almost in compliance with the criteria. We can almost say yes to your approval, but you are not in compliance with the code in the following ways. Instead of saying no, they can say yes if you bring this following thing into compliance. The standards are compliance and mitigating, and it also includes language that limits the conditions that can be put on. The major limits are It needs to be related to the impacts of your development. They can't ask you to solve somebody else's problems. You need to be related to the problem you're solving you're causing with traffic or something else, and it needs to be roughly proportional. I'm not making this up. The U.S. Supreme Court has said this, and almost all the 50 state courts have said the same thing. We understand that the city could have said no because the streets are not adequate. The city could have said no because it's too much traffic, because stays open. Instead of doing that, they said the answer is yes, but you pay your fair share of the cost of dealing with this issue, but there are limits to avoid overreaching, and that's in that section on conditions. Modification comes up all the time. I got an approval, or my dad got an approval a few years ago, but things didn't turn out the right way, or the market has changed. I need to change my approval. And this lays out, okay, if it's a minor change, usually staff can take care of it. You don't want to make that a heavy process. If it's a big change, you need to go back to the people who gave you the first approval, because it's the same decision coming up again. And of course, that dividing line between what's small and what's big is different in different communities. We have put in here the general standards that most communities use, and we're trying to put into words. Is this a detail? Is this a minor adjustment that would not have affected the original decision? Or is this a big change? You got a new building, you're moving the building around significantly. There's something going on here where if this had happened, the decision to approve you might have come out differently. So let's send you back in front of the people who approved you the first time, because we're having the same discussion again. Those are what standard provisions are. Oh, and appeals. How do we handle the appeals? The general rules in this community are, if staff makes the decision, most cities want to allow staff to make many decisions according to clear criteria, because that's very efficient. You don't have to go to a hearing, so you want to do that. If you think staff made a mistake, or staff, you like what they did, but your neighbor thinks they made a mistake, how do you appeal? Those go to the Board of Adjustment, and that just says that. Anytime a non-appointed body, a staff member, is reading the law of the city and applying it to your property or your neighbor's property, and you think they got it wrong, goes to the Board of Adjustment. And their criteria is not, do I think this is a good decision? Their criteria is, did staff make a mistake? Staff, I'm supposed to draft a code that's tight enough that they can tell, did staff make a mistake? If staff did not make a mistake, then your appeal loses, because they don't sit as the second round of thinking this problem through. Staff had that responsibility. They're the check to make sure nobody read this wrong or made a mistake. That's how appeals go. That's what that section says. There are other places in the code where, for example, if you don't like what city council did, you need to go to court. There is nobody who can tell city council that the decisions they have to make are wrong under the code. You need to go to court and say, my own city council violated the laws that they adopted. So it clarifies what you do when you're not happy with a decision. I talked about conditions on approval. I do want to talk a little bit about complete application. It has not been a big deal in Columbia so far. But almost without exception, cities that scratch their heads and think about how to run an efficient, predictable approval process come to the conclusion, and I endorse it, that you need to file a complete application. And again, this has not been a problem in Columbia, but we've put it in here. It is not fair to give a sketch drawing and expect them to review it and then show up with more detail later, and the neighbors say, well, if they'd shown me that, I really would have been upset. It's not fair to say, I'll come up with that study later. It is fair to say, you need to file a complete application. We need to get the detail right. If it's a preliminary application, you don't have to do engineering. But we need to state it, and I'm just letting you know, the draft says, when you walk in and say, I got 2/3 of what I need and I'll come up with the rest, would you run it down the line? The answer staff is supposed to give you is, no, we will not. That is not a good use of our time, and it's not a good use of the public's time, because we may have to go back and do it again. If you don't, I'd be happy to get comments that you don't agree, but the point is, if you don't agree, I'm going to ask you why. Because if you think the city is requiring too much detail too early in the process, we can change that. That's the usual reason. I don't want to provide that amount of detail early in the process, and it's our job to get that done reasonably. But other than that, it really is almost universal that people don't do that anymore. Okay, here's the table I promised you. I wanted to point out a couple of new things. Here is the table of procedures. And you can see the left-hand column is all the, this is not the whole table, but it's most of it. I think I have the rest of it on the next slide. Okay. The next column says, what section would you go to find this procedure? The next one says, is the department involved? Yes, and DCD means the Department of Community Development, and D means they make the decision. So this first part of the table is mostly things that you just apply for, a building permit. You just go to the department, and that's who issues the permit. Zoning compliance. Am I okay with zoning? Those are staff decisions. That's what it says. Don't like it? Go to the Board of Adjustment. The red box is a new thing. It says, remember, we're doing form-based zoning in downtown Columbia. I think it's important to build in a way to get some flexibility into that process, because I've already told you the standards are tighter than for normal zoning. There's more controls on your building. Well, whenever you tighten the standards up, you're going to run into situations where you think, well, he doesn't quite comply, but it's not a bad design. It's actually a good design, and I think it's equivalent. We have come up with a new standard. This doesn't exist in your current code that says, if you can't meet the standards, where do you go? Answer, minor deviations from that, and there are criteria in there. Staff has the authority to adjust those according to criteria. If it's major, it's going to go to the Board of Adjustment. So that's where, and that's similar to what I said earlier in terms of modifications. We can talk about that dividing line, but I think the principle is there. You want a staff that can do minor adjustments. That's how you get good standards and let judgment be made in those cases. We just have to define what it is. So that's one of the new things that's in this code. Here is the rest of the table. And I wanted to point out another thing. These are, you can see if you look down the left-hand column, there are not that many things, but subdivision is a complex thing, and so there are many conceptual subdivisions, minor subdivisions. So many of these lines only apply to the subdivision of land. But up at the top, early on we said the new code will have a mixed-use neighborhood scale district in it. You now call it C1. The uses involved are broadened on that. You also have a kind of a corridor business, not downtown, but the stuff that's on Business 70 and Arterials, Providence. That's called C3 today, and it would be called mixed-use corridor community in the future. So those are two mixed-use districts, and what we've said is, in the case of the neighborhood, where it's supposed to be walkable, there's an alternative set of standards. You can follow the current standards, or you could opt into or get into the more walkable pedestrian standards. Put the buildings up next to the street, make it more walkable, you can have less parking required. In the case of C3, which is more your bigger commercial areas, we try to put density near where your bus system is operating, or hopefully will expand in the years future. And we say, if you put the building close to the street, you can have less parking and you can build a bigger building, because we want we want the density where it will reinforce your public transit system and offer you. Now the question is, how do I opt into those? And the draft in front of you says you go to the Board of Adjustment. We've had an afternoon of talking with staff and the city attorney's staff here to try to make sure that people are comfortable with that. And we think we can do this in a way where either it is so closely drafted that staff can do that, or you do have to go to the Board of Adjustment on this. Now, that's not a decision. The decision is to refine the language to make it tighter so that no one accuses the city of actually making such a significant change in the standards that are available that there was an opportunity for discretionary decision that wasn't adequately controlled. And therefore, what you don't want, guys, is somebody coming in and saying that was a rezoning. Under Missouri law, Don said it was just a choice of alternative standards. It shouldn't be hard to do. Let's keep it out of the political arena. But I'm saying that under Missouri law, that was a rezoning. You should have used a different process. And because you used the wrong process, it's invalid. And by the way, the other decisions you made along those criteria are also invalid. And so we need to tighten up the criteria by which this is done. But that is, I'm pointing out the second edition of a process, which is that one there. Conditional use permits, again, we've had a discussion. Right now, the ordinance lists that you can, in certain zone districts, some uses are automatic and others you have to ask for permission. Today, those go to the Board of Adjustment. That's an unusual way to handle it in newer codes. It's an old way. Older codes were drafted, some know it this way. I would prefer it to go somewhere else. I'd prefer it to go to Planning Commission. But under Missouri law, I'm told that if Planning Commission can't make decisions, it goes to City Council. And so right now, we have put it, this second box says it's reviewed by Planning and Zoning, and it goes to City Council for decision. I'm worried about that because although I've already told you that I don't think the Board of Adjustment is the right place to make those decisions, I'm not sure City Council is either. And I'm worried about the politicization of things that are not political now. So all I can say at this point is that we are trying to talk about whether there's a way of drafting that and to avoid this result, but I want to highlight for you that it's not a new process. You have it today. It's going a different direction, and that's because of interpretations of what needs to be done under Missouri law. The question that comes up is, under Missouri law, if it's a zoning change, it needs to be done by council. Is this a zoning change? That's the question. Is this a zoning change? And that's the discussion we're having with city attorneys right now. So this is, I think, unresolved, but there is not one opinion as to how it should be resolved. We're going to have to work on it. I want to do 2 slides just of changes to highlight some other things that have come up here. That your current code has very minimal requirements for when you do public notice. In practice, the city has been sending out notice much more than that. They only had to be sending out notice and publishing notice in a few cases. But in fact, whenever it goes to the Board of Adjustment or whenever it goes to Planning Zoning Commission, they do notices. The text has been revised to match what they actually do, not the little minimum that they're required to do under the certain current code. There are cases out there where if I apply for a use that's protected by the First Amendment, that usually means a sign or, heaven forfend, an adult use, that's free speech. And the city does not have to approve it, but it has to have a venue that allows me to do that kind of speech in the city. There are cases in the recent years where the court has said, your ordinance is invalid because I could be applying for a sign and you could just stick that application in a drawer and just decide that it's too unpopular and you're just going to delay me. Your code needs to have a time frame. Your code needs to say, you make a decision on this within a certain amount of time, and if people are unhappy with the decision, they get to appeal, and the Board of Adjustment gets to decide that appeal within a fixed amount of... The courts haven't said 30 days, 45 days, 90 days. They have said, in 2 cases so far, the fact that you don't have a time limit is a chilling effect on free speech. People won't apply for signs or adult uses. I think this may also apply to churches, but we don't have any cases out there. Things that the federal Constitution protects, you need to process those applications in a timely manner, even if they're unpopular. So we have included some time limits in here too, for legal reasons. We've divided, I already mentioned that this question, I need to modify my approval. How do I do it? We've divided it into major and minor and done that. We have tried to clarify the criteria that are used when you appeal, and we have added a provision in there which was recommended by the City Attorney's Office, and I agree with it. If you appeal a decision of a body, either the Board of Staff or it's usually staff, you're appealing their decision, and you're asking the Board of Adjustment to reverse that decision, it needs to be based on substantial evidence in the record. Guys, this is when staff makes a decision about how the code applies to your property, they're sort of acting like a judge. And if you're going to question that judgment, they're only a judge in the sense that they're not making law like City Council. They're applying law to your property. And their reasoning of that needs to be put in writing. And then if you can't say, I just think they're wrong, you need to give some evidence as to why you think that is a wrong decision. And so that is it's not uncommon in newer codes to say you need to provide substantial evidence. We've put that in writing. There are 2 provisions. We were asked to draft and bring together about 3 or 4 ordinances, zoning, subdivision, and some minor ones. And you had some older provisions. There was a chapter on how does City Council establish where the streets in the city run and what are the setbacks. That was in a separate chapter. Those aren't needed because the city had those powers under its zoning and subdivision powers. And so there were 2 obsolete sections that we deleted because it was belt and suspenders. They had those powers, and they weren't even, I think some people didn't even know these powers existed in the city code. So they're gone because they're covered in other sections. Here's an example of flow charts that we put in for each of the specific uses. The legend here is Each one has a name. It tells you where you apply. The one on the right is subdivision, which is about your most complicated process. The one on the left is just getting a permit or a plan approved. It tells you who makes the decision. The gray box says who makes this decision. The Board of Adjustment makes a decision. The P says there's public testimony at this. Many times, permits don't get public testimony. They're just filed with the city, and the city approves them, and there's no point in having public testimony. And the question is this man entitled to a permit? So there's sometimes that you don't get a P. Sometimes there are in different procedures. Here are the last slide, I think. I think it's the last slide. In the current ordinance, there is a chapter on urban renewal projects and a chapter on public housing projects that say you need to get city council's approval for these things. It's unclear whether it meant you can't even file for these things until you go to city council and say, hey, can I do an urban renewal project? And then you start bringing your process through. Well, the way urban renewal works, it can't even be filed unless city council has approved something. And public housing should be treated just, frankly, like private housing. So I want to point out those two special, kind of unclear, what did this mean, are gone from the code. If you're doing housing, a housing project in Columbia, whether it's private or luxury or a student, frankly, or public, you will be treated according to the multifamily housing rules of the city. There's no separate process. It'll get to city council if it's not allowed by right. But you're not going to go to city council because it's in one of these two categories. You're going to be treated like every other property owner. But again, you can't be doing an urban renewal project unless they had approved it to begin with anyway. So it's not like you get a freebie. I've talked about consolidating the variance provisions. We had this discussion today. In your current subdivision ordinance, it says they're not supposed to approve it if it's inconsistent with the comprehensive plan. I extended in the draft that to all the zoning and subdivision decisions. Not variances, not minor things, but big things need to be consistent with the comprehensive plan. I've had some comments that people don't want that because A, plans get out of date. 5, 8 years from now, you may be doing another comp plan. You may not want to be following or tied to this one. But also that there's some ambiguity because the comp plan says what it says. But neighborhood plans get adopted after that, and they say things in more detail. And that this is blurring the line between plans, which are supposed to be advisory, and zoning, which is regulatory. So I have had pushback on that says I don't think you should have included that, Don. And I've got to think it through and see what we want to do about that. I understand the arguments. Most cities struggle with this. To what degree, we just invested a lot of time in our comp plan, to what degree do we require land use decisions to be consistent, and to what degree do we not? And so I just acknowledging that there's not unanimity about whether this should be in there at this point. In stormwater and floodplain regulations, again, recommended by the city staff, is that these are things where stormwater is an engineering matter, and so are floodplains. It's hard for city staff who are not engineers to know whether your comments about stormwater and floodplain are correct. So I'm pointing out that the code now says you're going to have to submit data signed by a professional engineer. If you say this is where you're lifting it out of the floodplain, you need to have an engineer saying that. So and city's engineering staff say, well, I think I can trust this. It was signed by a professional engineer who has a license, and if he's wrong, but I don't have to re-guess as an engineer, sign off on a non-engineer's statements about floodplain and drainage. Well, I don't know if they're right. And so that's included now. And then finally, I mentioned this, that there's a change in that provision. Let's see, I already talked about that one, I think. Oh, I did want to point this out. This is unusual to me, but just in case anybody out there is a land subdivider and says, Don, can I get a variance from the provisions of the subdivision regulations? Can I change something from the subdivision regulations? Well, that's not how it works under Missouri law. If you want to have alternative standards applied to zoning, you ask for a variance. If you want to vary from the subdivision standards, you propose those additional standards as you submit your subdivision. It's a design option or a design adjustment. And you file it with staff, and they make a recommendation on your subdivision and whether that adjustment is good. And then Planning and Zoning Commission makes a decision. I'm just pointing out, you can do it. It's called something different. I kept asking them, come on, guys, tell me. Somebody's playing hide the ball here. Tell me how I get a variance from subdivision in Columbia, and they said, you don't get a variance from subdivision in Columbia. You don't in Missouri law. You apply for an alternative standard, and they weigh your platting and your lots against that alternative standard. We've clarified that in the code. Same applies to appeals. If you don't appeal the staff's recommendation or decision or planning and zoning on a subdivision, you take it to the next level and say, I think they were wrong. So there is one path to subdivision approval, and deviations from it just mean you're going to make your case at the next level. If staff doesn't agree with you, you're going to make it a P&Z, and then you're going to take it up the ladder. So I did point out that today subdivision of lots is usually done in 2 steps: a preliminary plat, and then a final plat. The current regulations say that a preliminary plat is good for 7 years, and we have changed it to 3 years. 7 is the longest I've seen anywhere. It puts the city in a difficult position because in that 7 years, first of all, you don't require a lot of engineering detail. You can get a preliminary plat without a whole lot of engineering work. But what if 6 years go by and now you've had 3 council elections and they have changed the standards, but this person is coming in. You have problems with people trying to say, I'm entitled to a final plat under provisions that were not endorsed by the last 2 councils that we elected, but you did it 6 years ago, so I'm entitled to it. Most cities handle that by saying, no, it's not good for 7 years, it's good for 3 years. And then you go on from there. And that's 3 years is 1 or 2 or 3 years. Some cities say 1 year. Some say 2. 3 is about as normal as I would say that it's not 7. So, and then finally, in subdivisions, and I realize I'm in the weeds here, but we're just about done. Your current if you subdivide property today, you have to agree to build improvements. The current one says if you can't build it within that time period, you get a 5-year extension. That also is not a mainstream provision. The mainstream is to say you need to be doing your subdivision per your agreement. If you can't because the economy went down, because you lost your financing, because something happened, you can ask for a 1-year extension. You can do that 3 times. But we're not going to hand a 5-year extension. We're going to say, okay, we understand. At some point, you do need to say this subdivision is dead. We will let it move forward. You're going to have to come in. We're going to have to reconsider what the subdivision improvements are, and you're going to have to gut back and talk to the city about whether you need to do different or more than what you did before. So it's the usual period, 3 1-year extensions instead of 1 5-year extension. That's a change. Finally, this is typical. Some of you may not like this, but the current provision says the city can apply to rezone property or the property owner can apply to rezone property. In practice, most cities say if you've got property in the immediate area, you can apply. You can't get an approval, but you can apply, and that is what is written in here now, is that if you own property in the area, and you can apply for a zoning change. Protest procedures for PD zoning. You have used planned development zoning a lot in this city. We're trying to reduce reliance on it. If people don't like a zoning decision, Missouri law gives them a process to protest it. And if they protest it, you got to have more votes on city council to override that protest. Then you had a different set of provisions for planned development zoning. We have aligned them and say, look, whether it's a rezoning to a standard category or to a planned development category, it shouldn't matter. If people protest it, there's a certain way to protest, and the consequences are the same. And so we have tried to align those two so that there's one set of rules for protesting. We've talked about how in past there used to be 4 different categories of planned development. They're now in 1. We have required, unlike past practice, that when you apply for planned development zoning, you file a development plan. We need to do some more work, to be honest, to refine the level of detail, because we don't want you to try to pre-plan the whole site. That won't work. We know that that's not going to work. Architecture, engineering, drainage, that stuff should not be done. However, we had long discussions with this in the city, and there's not unanimity. The prevailing practice around the country is when you apply for a planned development zoning, you need to put a development plan on the table, and that's going to be good for 3 years. We need to get the level of detail right, but you can't just have a general statement of what you're going to do and then go out fishing for clients or clients for tenants. So I'm trying to bring this towards the mainstream practice, because even though I think many property owners in the city have benefited from planned districts, there's a general sense that they're overused, and it's hard for the city to manage them. And they all go to council. They all get negotiated, and that is not how a zoning ordinance should operate. You should not have to have a discussion in council most of the time. So we're searching for various ways to narrow the use of this tool, and one of the ways is, well, guys, it's not just a blank check. You got to put in more than a statement of intent. You're going to have to do a development plan to show what you're planning on doing. All right, I think, and then I mentioned PD plans expire 3 years, and there's a 1-year extension possible. Let's see what else we got. We have clarified that if you have a non-conforming building, one that doesn't match code, you can do repairs. We actually, older codes say we just want you to we don't want you to invest in the property at all. The new one says, go ahead and repair it. We want you to do it. You can't expand that building, but you can repair it and keep it in good repair. And then finally, and many older codes say if your house is damaged beyond a residential unit is damaged beyond 75% through a fire, flood, what have you, and you need to rebuild it, you need to rebuild it per the new code. Many cities are changing that to say, all right, we understand a business is an investment, and your store burns down, you can build a new store with your insurance proceeds, and you ought to be coming into compliance with zoning. Residential, the code now says, even if it's 90% damaged, if you want to rebuild the house in the location on the site that you had it before, you may do that. That is fine. So it's loosening up nonconformities for residential. There's just a sense around the country that usually residential standards don't change very much, and if you're unfortunate enough to have lost your house, the interest in getting you aligned with the details of zoning are less important than letting you rebuild the house that burned down or flooded. So that's in here now too. I apologize every time I said it's over. It wasn't over, but now it's over. So as always, it takes me longer and there's more details here. But I hope that lets you know that I hope we've tried to highlight the changes that are in here and can take any questions. Maybe before we do that though, Ryan, do you want to say anything from the city attorney's point of view and things I misstated? Okay. All right. We've had long discussions as to what is and is not possible under Missouri law to streamline the code. So, any questions on this highly exciting topic? Yes. Sure.
Hold on, I'm going to give you a microphone. We're not broadcasting, but we are filming.
I didn't understand that, and it may not be real important to me, but you said who may apply for zoning, and you said if you own property in the area. I don't understand I don't understand that.
Well, here, we'll go back to that where we could. Most codes say that, to be honest, most codes say any human being can apply for rezoning. The first question, for their property or for another area of the city, all you're doing is asking city council to take an action, and they're going to process it through planning commission and say it's a good idea or bad idea. So in zoning in general, the rule around the country, the normal rule is council can initiate it, planning commission can initiate it, or a property owner in the city can initiate it. Your code today says council can initiate it or you can initiate it for your own property. But your neighbor can't initiate it because they want to do an overlay zone for the neighborhood to protect the character. They can't do it. So that it's just bringing you a little closer to the mainstream, saying, no, if it's your neighborhood, and for example, it usually comes up with a dead commercial property at the end of the neighborhood, and the neighbors would really like it rezoned into something else, and the property owner is either not there or not cooperating. The question is, does it stay there forever because the property owner won't apply, or can they apply and ask the planning commission to say, based on the comp plan, based on neighborhood character, can we rezone this property? So it now says, yes, you can.
Is putting an overlay on something considered a rezoning?
Yes, it is.
Okay.
Yeah. It's the adoption of a new zone district.
Well, how did we do that under the current
I don't
one?
know. I don't, and maybe I'm misreading the code. Ryan, do you know if I misread the code currently?
I think that it would be previously council.
It was a planning commission asked for them to do it.
It would be something that would have to be lobbied for.
That I do know the answer to that, because
Okay.
since the planning commission can, if you lobby the planning commission or council, they can say, hey, this is our application and we can take it through. So,
Okay.
yeah. Yeah, sorry. Go ahead and then we'll come up
Should
here.
that slide then say property owners may apply for zoning map changes?
Yes, it's a typo, my typo. I apologize for the confusion. It is a change to allow them, and I can tell some nervousness out there, but it is to allow them to do it. Correct.
Well,
Yes.
and I think it was in '93, we adopted, I think it was called the Urban Development Overlay Code.
Mm-hmm.
And one of the big battles in that, and to some extent a success with, before that, it was 50% of the property owners, 50% of the square feet, or 50% of something.
Yeah.
And for whatever reason, the council at that time said, I'm sorry, nothing will ever happen with that. And so they added a very specific thing, because before that, it was always the 50%, whatever it was. They said, no, the council can initiate these things. Now, somebody has to apply, ask for it, and so forth, but the council could initiate. Now, that's part of the history. Now, that's not all overlays. That was specifically about central city things.
Yeah.
But that was part of the discussion.
Well, I think, as a practical matter, although I think it's the right thing to do in your code, I don't think it makes much difference, because if your neighbors are hot to trot about the dead gas station on the corner, they're going to talk to their city council person, and their city council person is going to support an application to rezone it. So this is just clarifying that it doesn't have to be the council, it doesn't have to be planning committee. They can, if you apply, you and your neighbors don't like your unpopular neighbor and you want to rezone their property, and that's what's going on, that'll come out at planning commission, that'll come out at council, and usually the council's very quick to figure out, does the property owner support this or not? If the property owners, I had this happen in my neighborhood, there was a car wash, a very popular car wash in my neighborhood, but the guy had conditions on his zoning, and he just ignored them. He just decided that this was America and he was going to run it the way he wanted to. And after about 5 years, the neighbors went to council and said, we're going to apply to change his zoning to make this, they applied to downzone his property for failure to follow the conditions on his zoning. And they were allowed to do that. Now, they didn't do it in the end. Council they went and had a talk with him and said, you're about to be downzoned if you don't bring your car wash into compliance. But they had the right to apply to do that because they were in that neighborhood. So,
Can I?
sure.
There was one of these things that you mentioned about, you used the word, whether basically a court would found that something amounted to rezoning.
Yes.
And the BO. And there are many of us who believe that half of the zoning on parts of College Avenue were spot zoned by going to the Board of Adjustment. If I understand correctly, that's what you're talking about.
Well,
It's the Board of Adjustment
yeah.
basically doing things that many people considered amounted to zoning decisions. And they used the term spot zoning, and I was just thinking, that's the kind of thing that you were aiming at there.
Yeah,
right?
and I'll just say one more minute. Yeah, the short answer to your question, John, is yes. I don't want to draw you more into this than you need to be. It's an unusual situation. I've talked to some of you today about this. I am used to home rule cities having the ability to give their planning commission authority to make some decisions. Apparently, that's not possible here. So, under Missouri law, Planning Commission refers to council, recommends to council. That leaves us with a tough choice. Either you go through Planning Commission and this becomes a political decision, or you go to the Board of Adjustment. And most boards of adjustment are not designed to make the kind of planning decisions and that's why I think you have this question. Are they really engaging in zoning? I'm trying to figure out what is the right thing to do, because I've heard loud and clear from the beginning. Obviously, we have to comply with Missouri law, but people don't like how political it's become. At least I've heard that loud and clear, that people both on the neighborhood side and on the business side don't like how political it's become. So we're just searching for how do we keep it out of that track where everything that goes through Planning Commission goes to council. And it may just be that we have to live with that, in which case I'm going to start looking at, can we reinvent the Board of Adjustment or something as another way of getting some decisions made that are less political. So.
And this is just a clarification, and Thad is over here. It had to do with, this applies to the cities, but at least what I thought I understand with first-class counties, the P&Z Commission there makes the decision. Somebody can appeal it to the county commission, but that's a different structure for the counties than it is for the cities. Do I understand that?
That's what I understand.
And that's still also a state law distinction.
Well, in fairness to your city council, it's not as bad as it could be, in the sense that if you, they put a lot of things on consent if they're not controversial. At least I understand that that's their practice. Well, if they're going to just vote it in by consent, it's an additional month, it's a hearing, it's cost, but it's not necessarily a political battle if nobody takes it off the consent calendar. It's not the same as an appeal, John, but it's like it. You might get lucky and not have to defend yourself at city council. They might let it go through. So I don't want to paint it that every one is a political issue, but I would prefer it if we could have planning commission make decisions, and then only if somebody was upset enough to appeal would you get to council. And I write those all the time. I'd like to be able to do that, but I don't think I can right now. So, yeah.
On the right to rebuild residential non-conforming
Yep.
buildings, does the entire building have to be residential?
The way it's written now, yes. If your house burns down, you need, well, you can do home occupations. You can do things that the point is to allow you to build a structure. You don't have to move the foundation. You can build on the same place you did on the lot, even if it doesn't meet setbacks, that's okay. But you're not supposed to broaden the list of uses. You're just trying to get your house back, and whatever you could do in the house before, you could do now.
But if the first floor was commercial and
Oh, I hadn't done that. We can tweak it if you'd like to do that way. I don't mind. The point is, this started in California. It started in California. No, don't boo and hiss, okay? Because they found over time that a lot of it really came up from multifamily. That if you had too many units on this property, but it was affordable housing, and now you were supposed to have 18 units, but you had 22, and it burned. City Council said, we can't afford to not rebuild 4 affordable housing units. We need to allow them to rebuild all the units they had before. So that has expanded into a general philosophy that homes are different than businesses. And we should say, look, the theoretical need to comply with everything in the code bows to getting people back in the homes that they occupied before. But I hadn't thought through the question of, all right, what if it was a mixed-use property? Could we do that? I guess I'd have to think about it. Yeah. I can come up with good arguments for and against, and I don't want to go out on a limb tonight. So, yeah. I gather you would like that.
Well, I want to think about it.
I do too. There you go. Sorry.
As I understand the process from here, you've released all 3 modules, you've
Yeah,
asked for
yeah,
public
right.
comment,
Yep.
you're going to wrap that all up into another draft and release that, and then that's it, and then it goes to council.
Well,
right?
it's going to take a little longer than that, but go ahead. I didn't mean
Well,
to
I just
interrupt
wonder
you.
if there might be value in allowing another round of public comment and then incorporating those comments into a revised draft.
If there are 2 possible questions there. I think I have a file full of stuff that people would like to see changed. So I think we should stay the course in the sense that, first of all, we ought to test it. There are people who are dubious about whether some of this will work or what the effect will be. So I think we should perform that part of the contract. And then put out this integrated draft so that those of you who've been patient and come over and over again start seeing the changes or seeing that we couldn't make them the way you wanted to. At that point, I'll be very honest. It's very common for cities to say at that point, okay, we got all 3, we've had the comments that you could change, we want to slow down and get another draft. But that's up to you guys. It's not in my budget, and I couldn't do it without additional money. And I'm not gunning for additional money. It is simply that if you made that decision, Tim doesn't like this. If you made that decision in the fall of 2015, you would not be alone. Many cities do because, to be honest, many people only read it when that one comes out. They want to see not only what we did, but whether we caught their comment last time before they know whether they're satisfied or not. So.
Well, that's exactly the point. I suspect that's happening this time, and you'll have the testing, and I'm wondering about the testing. Do you take actual projects that are proposed and do the testing on those, or do you make up stuff and then see if...
Usually it's a combination of both. It is, look, Don, these kinds of things are routine in our community. We want to make sure you haven't put barriers in the way and that you haven't made them either market impossible or awkward for the sites that they go on. So part of it is, we want to make sure this can continue to happen. Take a look at the corner of 4th and Elm and that gas station, that office building, whatever it is. Test this one and make sure we didn't shoot ourselves in the foot. Then we often get, I wouldn't be surprised if someone says, Don, I don't really get your alternatives on mixed-use neighborhood or mixed-use, transit standards. Could you show us the difference that would occur if we adopted this? What if I chose this rather than that? What would it look like in terms of an alternative layout? So it's often a combination between things that already exist, they want us to see how the new code would apply to them, and some things that are brand new that don't exist, and we've proposed that they ought to be allowed, and people want to see what they'd look like. And we haven't decided which of those it is, but it's a combination of both. Sometimes my clients say, Don, we don't have one of these, but I'd like to see what a 3-story mixed. I'd like to. I'll make it up. I'd like to see what something like Opus would look like. I want show me what we could do on a site of this many square feet with 3 stories of residential and ground floor retail. What would the code make that look like? Apply the standards and see. I don't know what would allow now, but I want to see at the end whether I like the layout. So I will let the city advise me as to which of the sites they would like to have tested. I will suggest to the city that you not make them all downtown, because I think there's been a lot of thinking about the form-based stuff. If you want us to, we will, but if I were them, I would think there are a lot of changes that need to be made in form-based. I've heard comments, they're too strict, they're too prescriptive, and let's fix them and do some testing. But that's the sexy project. If I was the city planner, I would want to know that something on the outskirts and the older neighborhoods was also going to fit in, and that I hadn't focused only on what was popular and ignored the kind of day-to-day real estate development. So,
Don, on the planned, now that we're going into one plan thing.
yeah.
And then you have all these other categories.
Yeah.
It seems like when Darwin Hyman was the mayor here that we started going to the thing of just about everything that gets approved is going as planned zoning.
Yeah.
And now this looks like that's backing off of that. So how do you make the decision to go for a planned zoning? Or is that prescribed too?
No. It's always up to the property owner whether they want to apply for planned zoning or not. Here's the goal of this effort, and you are not alone in your scratching of heads and wondering. I've had a lot of skepticism from all points of the compass as to whether this is going to work. The idea is to say, if we allowed a wider range of uses, which we think is reasonable in these zone districts, there would be fewer people trying to do planned districts because they were trying to get some use. Now, I can't stop council from wanting to limit those uses, but I want to get the right ones in the right districts so that we narrow the number of times somebody says, I got to do a planned district because I can't get the use I want without it. We're also trying to build in protections for the neighbors by tapering down and neighborhood protection standards and height and landscaping and buffering and lighting, so that hopefully, less often, the neighbors will say, Councilman, I want you to tell him we want to be at the table. I want you to tell him that his chances of a straight rezoning are not very high and that you'd like to see a plan on this one because we'd like to be there negotiating with them. I'd like to take some of the gas out of that tank too and have the council people say, well, what do you want? Well, I want this. Well, that's in the code. What do you want? I want more landscaping. Well, look at the landscaping you're going to get automatically. So the theory is, yes, your statement is correct. I would like to do less planned zoning by having the property owner and the neighbors both less frequently say, we would like this to be a planned zone to get what we want out of it. I'm trying to do that. I will say that I'm worried because the culture of negotiating things is so strong in this community, both among the neighbors and among the developers, builders, that I think it's going to be hard to change that. But I've been advised to tell you how other cities do it, and that's what I'm going to do.
Don't toss it. I was never good at catching it. So I had 3 or 4 things.
Okay.
One of them is, you have that file of comments. We've been dunning Tim to download all of that. So if he doesn't, will you do it?
Well,
Or you'll talk to him about doing it?
I will talk to him about
And I don't mean at the end of things.
I understand.
I mean now.
I understand.
So we can be looking at this for when we see this. And I mean actually really
I understand.
full transcripts, all this kind of stuff.
I can't promise you that. I will.
Okay.
You have asked him, and he's
Right.
heard me ask you, and I don't object to
And it's
it.
certainly not hard because you have the file.
Sorry.
I put the emails into a table section, number, and then the specific comments that they said.
Good. Of course, in many of these things I've asked you, so where in all of this did you fit in the meaningful basic sufficiency of resources precondition?
Oh, the do we have the water, the sewer, the traffic to the
I mean,
capacity
just
to
the
do it?
basic thing that actually is law every place, but we have people on city council saying the only precondition for building a building, getting a building permit is you've got the zoning. I mean,
Well,
literally
I
saying
I
that.
understand. Well, we haven't, the answer in many communities is you do impact fees. Well, you guys voted those down. I have not been asked to write impact fees, and I haven't done them.
And I'm not talking about impact
Okay.
fees. I'm talking about that basic sufficiency of resources standard.
But sufficiently, meaning what resources? Traffic? Road capacity? Water, sewer?
Actually, so what you're saying is you'd have to define those categories.
Yes, yeah, you'd have to do it. That's what they're supposed to be doing, and there are two flavors of this. Number one, zoning ordinances should be written so that the codes and the standards for the majority of development, I say 60% to make up a number, more than half of development, goes to staff and is approved because the zone districts have been written so that there is adequate capacity. If there is no adequate traffic capacity, you don't do a traffic study for every Taco Bell. You say, if there wasn't traffic capacity, we shouldn't have zoned that land to put a Taco Bell in. So we don't do it for the majority of them. When there's a discretionary decision, and I'm talking about conditional uses or a planned district or a subdivision, I mean, the fundamental way America does that is when you create your lots, we try to make sure that there's adequate infrastructure and services. And if there isn't, the city says one of two things. I deny you, or I approve you if you'll help provide those services. So it happens at that discretionary stage, but I want to be very clear with you. I try to draft code so that the majority, as much as possible, the zoning is aligned with the resources in the plan so that the property owners can say, I don't have to ask myself that question. If there isn't enough road capacity, they shouldn't have zoned it this way. And if they find out there's not enough road capacity, they ought to rezone it. But they can't study traffic every time it comes up.
And of course, you're talking about this the way the county does it, where it's in a rezoning.
Yeah,
And
Or
I'm
subdivision.
talking about this at the building permit.
I understand.
And occupancy thing, because, and I must admit, we may consider all this rezoning downtown. So basically, I get no help with what we're doing here.
I have not drafted something that will insert
that's
it.
fine.
Yeah,
We talked about that before.
No, I haven't.
I did have one of the people who,
Sure.
when I was campaigning, asked me, he said, would I support more strict stormwater regulations as part of the zoning
Mm-hmm.
ordinance? And I wasn't fast enough at the time, so just remind me of something. We have a set of standards for things like this that attach broadly and then attach to specific things. And do I remember correctly that we actually have, that's where we put the stormwater things. So they weren't by minute things, but they applied the whole classes of permitted uses, permitted zonings.
we have not changed the way in which staff evaluates development for compliance with stormwater standards.
But the model in this is, it's in those long details
Yeah.
of the standards that apply.
Right, and it's in engineering standards. Most of that kind of stuff is only intelligible to engineers. It's not in the code. The fact that you have to comply with the city's standards is in the code, and then the engineering documents are outside the code, and that's how you. But we haven't changed it. We have not tried to change the way in which that's done.
And I had two more things. I think it is only two more things, and then I'm kind of done. Oops. Folded pages. Oh, yes. I was interested in business about plants. Come to find out that, I mean, a number of council people just were very upset because they were told they had to vote on the conformance of a final plat to a preliminary plat. And if I understand correctly, that's the state law. I mean, it's not like the city decided to do that. But if I understood in your comment here, you were talking about the time limits and these kind of things, because it's still the state law that councils in the state of Missouri are required to take that vote on a final plat and make the judgment as to whether it's in conformance.
Well, let me maybe draw Ryan into this. We've divided it between major and minor plats, and most
Oh,
cities
okay.
do. If it's a small thing, then you take it to council, because Missouri law does say council approves plats. But, and I will let, Ryan can have rebuttal time in a minute. We have said that if it's minor, a small thing, and you're not having to devote infrastructure, the sewer's in the ground, the water's in the ground, you got road frontage, there's no utility easement, and there's no need for you to give right-of-way to the city. You are just dividing one lot into two, and they all have frontage and utilities. That does not go back to council on a final. That's you just take it through once. It's just a drawing and engineering, but you're not even doing engineering because there's no utilities needed. So you're drawing property lines that comply with the code, Council does have to act, but it doesn't go around. You're talking about major subdivisions where you had to go through preliminarily, and then and under this draft, you have 3 years to come back and say, I'm finaling my getting my engineering standards, my road sections and things approved here.
Right.
That does have to go to council, and I don't, it has to go to council because it involves giving land or to the council or utilities that council controls. It's not that everything always has to go back to council. It is that you can never give land to a city without the city agreeing to take that land and them deciding that this is a street that we're ready to own and maintain or drainage that we're ready to own and maintain. So your comment is yes, they have to go. The real reason is not usually that they are supposed to decide how it complies. Usually they are trying to decide that the things that go along with a subdivision, the utilities, the street dedications, are things that the city is willing to take on and perform.
And arguably, that was in what was really involved in getting the preliminary plat
Well, but
approved.
you-
And the state, but it's the state that mandates this regime.
State says,
And you've explained some of the rationales for that.
but your subdivision ordinances, regs are different than many cities. It's fairly simple. I'm not a land developer, somebody's going to yell at me for saying that. You have to do less engineering and drainage and what I would call kind of engineering of a subdivision to get a preliminary plat due. You do most of it on the back end. So when you say the way it was raised to you was, I feel uncomfortable trying to decide whether the final is consistent with the preliminary. That's because the preliminary was pretty vague and the final is but there's a lot of gap in the level of detail between the two of them. So it's because of the way Columbia set it up, and I don't think that the fact that it is so general at the first stage and so specific at the second stage is mandated by state law. I think that's something Columbia decided.
Oh, okay. So the idea that there is
Is that true? Yeah, okay.
you know, the basic thing is just final. And
Yeah, right.
in the process, then, have you provided kind of more detail and so forth about the preliminary? So I mean, basically to remove ambiguity, all
I
that
have
kind
not.
of stuff.
I can't make you happy on that one either.
Well, I
haven't.
just wondered whether
No,
you
I
did.
haven't. We've left the levels of detail that you need to do for preliminary and final. That has not changed.
But
There-
that is basically a council decision if they wanted to change
That's right.
those things.
That's right. There are changes to the subdivision. We've put in a section that says that you need to do a basic land analysis at the first and stay off of sensitive lands. And if that means you need flexibility in lot width and area, we'll give it to you automatically. If you need to stay off of sensitive lands and now I can't get this many lots in, and it's not floodplain. Floodplain, you bought it, you knew you were buying a floodplain, that's your problem. But if it's other stuff and we need to adjust it to allow you to get the same number of lots, that's fine. We've put in cluster bonuses. If you give more open space, you get more lots. We've put in solar orientation. So I don't want to say that subdivision regs are the same. They're different in terms of trying to get better land design and allow people to do more creativity. The level of engineering you have to do to get approval at the beginning has not changed.
My last thing is, if I understood correctly, when you're talking about the idea of the complete application,
Yeah.
and that actually there's a process.
Yeah.
And basically, once you define what that means, the complete, if it doesn't show up, the staff is to say no.
Yeah. Well, staff is to tell you that it's incomplete, give you time to get it complete.
Right.
And then tell you, cities do two things, and to be honest, I can't remember which way I wrote it. Either they say, you send you a letter and say, look, we gave you 30 days or 60 days and you haven't contacted us, we can't process it, it's now inactive. Meaning, don't expect us to start it down the road. I have had some clients in the last few years say, Don, that's not good enough. Tell him we're going to mail it back to him. We're not going to keep his files for him. He filed it, we contacted him, he didn't respond, he hasn't come in and said, give me another 30 days. Why am I his filing cabinet? I'm going to mail him back to him and say, start over. So, I haven't written that in Columbia, but I'm saying that's either you tell the guy it's not going anywhere, live with it, or you say, you seem to have left something with us, take it back. So, okay.
The reason I asked this was the emphasis on the complete application and the process. We're going through this process, we do step by step.
Yeah.
If something is wrong here, it gets fixed or addressed at the next step.
Yeah.
And actually, the city is in a court case right now that has very much to do with what many of us consider is, well, the Opus people never applied for a permit. It was never denied. And appears on the council agenda, approvals that approve these things. that it really didn't, there literally was no application.
Yeah, well, I don't.
And so I'm wondering, what I'm hearing here is some emphasis on paying attention to that step-by-step process and getting that down clearer.
Yes.
And that some of us may find more comfort in that going forward.
That one I can make you a little happier on. I
Good.
think that's right. I want to be clear. I know that Opus was controversial. You've had 3 or 4 controversial things since I started here.
It wasn't just Opus.
I understand.
There were a whole bunch of
I want to be
development
clear.
agreements
This
that
is
went this
largely
route.
Clarion suggested this. This was not staff. I suggested it because I think it's a best practice.
Mm-hmm.
In some communities, they've gotten in the habit of starting things down the road and then saying, well, he'll fill it in later. And they get to a point where somebody has submitted something well along the way, and the planners get really nervous saying, well, if we'd known that early on, we would have made different decisions. We've wasted some time, and now we're partway through an approval process. It's going to be hard for us to deny it. We're going to have to approve it with conditions or approve them and let him tell him to fix it later. And once again, this has not been said in Columbia, but I've worked in communities where they say, Don, that's the real estate development game. Don't tell them what you don't want to tell them until it's too late for them to actually tell you to stop doing the process. And so I am advising it not because I've been told that in Columbia, because I have heard other clients tell me, and I think it's a bad practice. I think it's not the way it should work. So that is what we're
Well,
trying to do.
actually, the city right now is beefing up what they're going to require in plans because by accident, they allowed somebody to build something that turned out to be a garage because the level of detail wasn't enough, and they're fixing that right now. This sounds like going down that kind of direction.
Well, and I'll say one more thing that I mentioned to some of the stakeholders this morning, and that is that, and I wasn't aware of the actual intricate mechanics of it. Your code apparently is kind of like a lot of older codes that I've worked with, where basically, if you don't meet the code, you may know that you need a variance, but instead of saying, I'm applying for a variance, you're applying for a building permit and getting a recommendation of denial, or getting a denial, then you go look for a variance. The code should say, if you know you need a variance, just apply for a variance. You don't need to get a piece of paper saying, this doesn't comply with our code. You just say, I know I read the code. I need a variance. I'm applying for a variance. So you mentioned earlier there never was a denial. In most modern codes, you only get denied if you submitted something that you thought complied and you didn't get a variance and you don't comply. Now you get a denial. You don't get a denial just because you haven't gone through the steps that you required to go through the special permits to get a yes. That you apply for the yes. You apply for those approvals. And
The problem was not getting, the problem was the staff or somebody then went to the council to get approvals for things completely and running.
I think I'm being
And
drawn
so
into the
the
Opus
idea
discussion.
that the preserving actually staff resources in law, it's preserving judicial resources. You don't get to come to court and waste our time. Those two things kind of dovetail here. That if this is part of reinforcing that part of it sounds pretty good.
I view it as transparent government, and we just want to make it clearer. I want to make it clearer. So, yeah, sorry.
John, you and I both got more than 3 minutes tonight. We-
All right.
What about when you started talking about the idea that there has to be more completeness in the application up front? Does that mean that we're going to change the way that the process of approval works with city staff? Because sometimes the projects don't change because the developer asks for the change. They change because the staff or comments come back that require an additional change, and then you have to go back and talk through it all again.
No. Well, that's not, the intent is not to change that. That happens in a lot of permits. You
Right.
thought you complied, you go in, they say you don't comply, but if you made this change, it would comply.
Right.
But that's already being processed. What I'm more worried about, things that are going to Board of Adjustment or that are going to planning and zoning or being processed through the other city agencies, Public Works and Fire and things like that, that not start until they get a complete, I didn't say a correct application, I said a complete application.
Okay. Yeah, I wasn't clear. I didn't understand if that means that the process becomes longer, or if it's shorter, or if it's...
No, I don't like the idea that you have to have a perfect application. I mean, there's some cities, if I set a time limit, if I said, look, you ought to have a 60-day time limit for this permit, staff would start not accepting anything until it was perfect, so they could then meet the time. That's what happens. When you put short time frames on things, staff gets more picky and says, well, no, I'm not going to accept it. I'm going to clock's not going to start till I'm happy with this thing. So I don't believe that. The intent of this is not that you have a correct, you have filed the pieces of paper that need to be there in order for staff to make this decision. They don't have to be right. They can tell you that you read the code wrong and something's different. But you don't get to say, and once again, it's my kind of best practice. It's not something I'm aiming at Columbia because of a specific abuse. But it is bad practice to say, and it happens. I know I haven't done my landscaping plan. I'll do it later. And I'll get it before it gets down the road. And the answer is, well, then you see the plan and say, well, you failed to comply. And matter of fact, now that I've looked at it, you can't comply. But we're halfway down the road, and now we recommended approval, but we would have recommended. I've had cases where staff puts out the staff report a week before a hearing, and then 3 days before the hearing, the guy files the piece of paper, and staff says, well, if that's the missing piece of paper, our recommendation changes. That you told me you'd draft this to comply. It doesn't comply. I already handed the Planning Commission a report that said, I support this, but I don't support this because you're not in compliance with the law. So it just it avoids that game playing, and it avoids the kind of embarrassment that comes when you haven't done that work before they start making a recommendation on your approval. So.
Well, you're aware of paragraph D being presented to the council at the P&Z 15 minutes before a council meeting. This has been the history of collective action. It has been the regular practice.
Well, it wasn't driving my decision. I was doing it based on a best practice, so, yeah.
You had to clear about that.
I understand, yeah.
So does the process under what's been proposed, is there an opportunity for kind of a pre-filing concept review like we have now?
Pre-application conference, yes, that's right. I think you should always have the ability to just go in and talk. We just have to be clear. When you go in and say we're just talking, then you're just talking. You know, you're getting staff's opinion, you're getting their thoughts. You're not going to be able to hold it to, well, you said you'd approve it. I said, no, I showed it to you, and you said you didn't see any problems with it, but you didn't have the application in front of you, so you're not going to be able to bind them. So.
Well, and John, to what you said, though, yeah, sometimes people do bring in things like 15 minutes before the meeting, but sometimes the thing gets changed at the meeting by the council
Yeah,
members.
I know.
Okay.
Yeah, I wasn't thinking that the council shouldn't allow it, but the council doing its way of doing things has been equally problematic.
Well, I don't want to shut off the questions, but if people, you got the whole thing in front of you now. Oh, by the way, I will say this. I keep forgetting what we have and haven't talked about with my client. I was asked to do a summary of major changes for the thing just because people said, well, it's all out in front of us. Can you help us get our arms around? I said I would do that. And I actually had some people say, could you just give us your advice as to how to get our arms around this and start reviewing this? And I said I would do it. So I'll send you guys a 2-pager, we can review it, but so that might be helpful to people too, just to point them to. Now, as you know, there are hundreds and hundreds of footnotes. Don't accuse me of glossing it over. They're there for you to read, but as I have in these other things, I think I can highlight the major things and say, if I were you and I was trying to figure out how this changed, this is the way I would look at things. So, anyway.
And then, Don, comment period on Module 3, we're going to give about a month.
Yeah. Why don't we say end of May? It would be fine. I'll give you 6
That's
weeks.
6
because,
weeks.
Not because you're slow, because I'm busy. So there's no point in you getting me comments that sit on my desk for 2 weeks. So why don't we say end of May? I will start working on the ones I've got already, but I'll deal with these as they come in. And
And we all know what happens in University Town over summer.
Yeah.
We are going to be running a little bit short on community, so it's probably good that we're doing the testing exercises, which is more of a technical exercise, and then we'll resume reviewing text as the school year picks up again. In the
Well, and
fall.
I want to be clear. I do not object at all to the suggestion that was made earlier. Maybe we need more time to review it. Several of you
Yeah.
said that. And that will be said more and more,
Yeah.
because it's not, even though we've tried to make it clear, it's not simple. And
Yeah.
my advice to you is don't slow it down now. Get an integrated draft with the corrections put into it so you can see what your opinion is about the corrections, and then have a discussion about whether more time is needed too, or whether you want to pay some. You don't have to pay me. You guys can take it from that point if you want to, but to do another draft of it, or to say we got another round of it happens over half the time that people say, and I have no fear that this is going to be rammed down. I mean, there's so much skittishness over this thing that It's not like it's going to slide down through Planning and Zoning Commission and into City Council, and they're all going to approve it before you have a chance to do anything. Everybody's nervous about this. I'm confident you'll get there, but the point is, it should take as much time as is needed so that when it gets to P&Z, they don't have a lot of conflict. There'll be people testifying, but the issues that we're able to identify ahead of time, we've made the best compromise we can, and they're just left doing what they would do on regular thing. Or let's hear testimony and see if we think they got it wrong. So,
Yeah, and what I said about end of the year, that's a goal. I mean, that has been our target since we began. Events are going to take their course. It's going to be out of our hands, the schedule is, because things will
well, once it
develop
goes
that
to
we can't
P&Z, you're totally out
anticipate.
of control. They can take as long as they
And-
want to send it forward. I'm the guy who's pushing it forward. That doesn't mean I'm a shill for the neighborhoods. It doesn't mean I'm a shill for the staff. It means I know that the people think hardest about this, and you get the best decisions when it becomes imminent and about to happen. So I want to get it there so that people who have decided not to read it decide to read it, and then we can get it, and then you can make anything you want. But I'm going to be in the background pushing, whether you pay me or not, because I want you to get it to where the really hard decisions are going to be made. So, okay.
Well,
Thank
if
you.
If Mr. Elliott is not tired, he really ought to be. I suggest we wrap now, but we do have this room for a little while longer, so if anybody wants to approach him privately, just come on up with your questions. We have the press here too, so we'll stay in the room for a little while longer, but I think we'll end the Q&A right now. And thank you very much, Don. It's a nice presentation.